Review of the Penal Code Act and Criminal Procedure Code Act. The Zambia Law Development Commission, ZLDC, is a statutory body established under the Zambia Law Development Commission Act, Chapter 32 of the Laws of Zambia. The ZLDC's primary mandate is law review. In 2011, the Minister of Justice instructed the ZLDC to undertake a project to review the Penal Code Act and Criminal Procedure Code Act. This instruction was prompted by calls from stakeholders in the criminal justice system who observed that the two acts have never been comprehensively reviewed since they were enacted in 1930 and 1933 respectively, and as a result, they have archaic provisions that do not reflect contemporary times. Over the years, specialized acts that contain criminal offenses and penalties have been enacted, and this has resulted in inconsistent penalties for similar criminal conduct. And the two acts were enacted by the colonial government, and it was time for the country to replace these laws with indigenous laws. The main objective of the project was to develop comprehensive criminal legislation, while the specific objectives were to address the question of whether or not to consolidate all offences in the Penal Code Act and all criminal procedure in the Criminal Procedure Code Act. Identify and remove archaic provisions in the law. Identify lacuna in the law in order to introduce suitable provisions. Identify and recommend the adoption of international and regional best practice. And recommend the domestication of international and regional instruments. Appointment of the Technical Committee. At the request of the Commission, in 2016, Cabinet appointed a committee of experts in criminal law to provide oversight to the law review process and to make recommendations. The Technical Committee was chaired by Honorable Mr. Justice Chalum Chenga, representing the judiciary. Other representatives included Mr. Honorable Justice Kelvin Muzenga, representing the judiciary. Mr. Chipalo Bako, representing the National Prosecutions Authority, Ms. Maimbo S. Ziela, a legal practitioner in private practice, Mr. Tembo Simon, representing the Zambia Police Service, Mr. Raphael Mungole, retired Commissioner of the Drug Enforcement Commission, and Mrs. Mwenya Walia, representing the Ministry of Justice. At every milestone in the law review process, the Commission presented its research findings to the committee, and the committee would make submissions on the practical applicability of the findings and the recommendations emanating from them in the criminal legal framework. The committee made other submissions for legislative development based on their experience working in the criminal justice system. Methodology and processes. In order to achieve the project objectives, the Commission used qualitative methods of data collection and analysis. This consisted of a desk study, which focused on the review of primary and secondary data sources. The primary data sources included domestic laws such as the Constitution, subordinate legislation, and judicial precedents. It also included international and regional human rights instruments in form of declarations, conventions, treaties, and protocols, among others. Secondary data sources included laws, treaty body recommendations, and concluding observations from the mechanisms such as the Universal Periodic Review. As part of the methodology, the Commission also conducted comparative study visits. The visits were carried out in 2015 to countries such as Zimbabwe, Canada, Hong Kong, Australia, Uganda, and South Africa, from which Zambia learned best practice. In addition, the desk review on comparative study was extended to Kenya, Lesotho, and Rwanda, which were selected as being African countries with presumably socio-economic environment similar to Zambia. The Zambia Law Development Commission Act requires that a law review process includes stakeholder consultations in order to ensure that legislation is reflective of the socio-political values of the Zambian people. Consequently, the Commission also engaged stakeholders through consultative and validation meetings. Some of the engagement processes held between 2014 and 2021 were physical meetings, while others were held virtually between 2014 and 2021. Therefore, stakeholders' views and input informed the drafting meetings held at different stages and informed the content of the process outputs. In this process, some of the drafting team members were from the following institutions: Ministry of Justice, Legislative Drafting Department, National Legal Aid Clinic for Women, the University of Zambia, the Legal Aid Board, and Zambia Law Development Commission. Limitations. The process to review the Penal Code Act and the Criminal Procedure Code Act stalled and inordinately delayed due to inadequate financial resources at the Commission's disposal. Due to limited finances, the stakeholder consultations were carried out in 3 provinces instead of all 10 provinces. The limited physical consultations on the process was mitigated by the presence of institutions at national level. Therefore, despite the limitation here acknowledged, the ZLDC engaged with international heads and received information that was representative of the experiences of ZLDC general finding. The Commission generally found that the Penal Code and the Criminal Procedure Code contain provisions that did not reflect contemporary developments which other countries have provided for in their criminal law, such as the use of technology in criminal proceedings, had provisions that were suited to the colonial government, some of which were prejudicial to native Africans, did not adequately comply with international instruments that Zambia is party to, and had lacuna which require the introduction of suitable provisions. ZLDC findings. Based on the research that was undertaken, the Commission made the following specific findings. In the Penal Code, conflicting penalties. Besides the Penal Code, there are other specialized acts that equally codify criminal offenses and provide for penalties. The proliferations of penal laws have resulted in conflicting penalties. This makes the law uncertain, unpredictable, and unfairness in the treatment of accused persons. It also has the potential to perpetuate corruption. Colonial provisions. In the Penal Code, having been enacted in 1933, has provisions that are reminiscent of the colonial era. For instance, Section 2 of the Act provides that it will be interpreted in accordance with the laws of England, and Section 71 makes it an offence to defame foreign princes. Section 71 is an offence that was appropriate for the English monarch at the time, and it may be noted that the offence has since been repealed. Insult laws. Zambia's penal laws has maintained insult and defamation as criminal laws. These are, for example, contained in Section 68, which provides for the offence of insulting the national anthem. Section 69, which prohibits the defamation of the president. Section 71, which prohibits defamation of foreign princes. And Chapter 18, which provides for the offences of criminal defamation and libel. Whilst defamation and insult are objectionable conduct, these provisions compromise freedom of expression and are inconsistent with international law and used for political expedience. Other jurisdictions, such as Sierra Leone, Zimbabwe, and Lesotho, among others, have already repealed them. Derogatory phrases. The Penal Code and Criminal Procedure Code use words and phrases such as idiot or imbecile, which are derogatory and are contrary to established minimum human rights standards. Such terms also are in direct conflict with the Mental Health Act, which was enacted in 2019. Mandatory minimum sentences. The Penal Code provides for mandatory minimum sentences in inter alia, defilement, murder, stock theft, theft of a motor vehicle, and aggravated robbery. This prevents the court from being able to determine an appropriate sentence based on the facts of a case, and exacerbates crowding in prisons and correctional facilities. In other jurisdictions, such as South Africa, New Zealand, and Australia, Queensland, the court has discretion to pass a sentence that is lower than mandatory minimum, when it is in the interest of justice. However, sentencing guidelines are used to promote consistency of sentences. Non-bailable offences. Section 123, subsection 1 of the Criminal Procedure Code provides that a person charged with murder, treason, misprision of treason, or treason felony, aggravated robbery, and theft of motor vehicle, unless the accused is a first offender, shall not be granted bail. However, the Human Rights Committee in General Comment number 35 stipulates that pretrial detention should not be mandatory for all defendants charged with a particular crime without regard to individual circumstances. In countries such as the United Kingdom and South Africa, all offences are bailable and conditions to be met are clearly set out in the law. Child marriage. In terms of the minimum age for marriage, the Marriage Act provides that permission is to be sought from parents or guardians where a person under the age of 21 years is to marry. And under customary law, a person may marry upon puberty. However, the Education Act prohibits marrying and marrying off of a child that is in school. The other provision that impliedly acknowledges that there are circumstances when carnal knowledge of a girl below 16 years old is lawful. This was seen in the case of the People versus Chinjamba. In our argument with stakeholders, some wanted to have child marriage criminalized while others objected. In countries such as Nigeria and Malawi, minimum age of marriage is set at 18 years, whilst Kenya provides for prohibition of early child marriages in its legislation. Marital rape. There is no provision in the Penal Code that explicitly prohibits marital rape, and rape in the context of marriage has never been successfully prosecuted in Zambia. During stakeholder consultations, representatives from law enforcement agencies submitted that marital rape was not an offense. The majority of stakeholders submitted that criminalizing marital rape would compromise the sanctity of marriage. It was also submitted that victims may be given relief through divorce. However, this position is challenged by the Anti-Gender-Based Violence Act, which recognizes marital rape as a form of sexual abuse. Whilst this does not make marital rape an offense, a victim of marital rape could claim relief under the Act, which includes protection orders and access to a shelter. Marital rape is an offense in many countries as it is prosecuted as rape. Some African countries such as South Africa, Lesotho, and Rwanda have gone further to explicitly state that rape in the context of marriage is an offense. Minimum age of criminal responsibility. The irrebuttable minimum age of criminal responsibility in the Penal Code is 8 years. In providing guidance on the implementation of the United Nations Convention on the Rights of the Child, the Committee on the Rights of the Child recommends that the minimum age of criminal responsibility be no lower than 14 years. This was based on documented evidence in the field of child development and neuroscience. Countries such as Rwanda and Congo have a minimum age of criminal responsibility of 14 years. Bigamy. Stakeholders submitted that there was need to repeal the offense of bigamy as it is a colonial legacy. Zambian customary law allows a man to marry more than one wife, and therefore this should extend to statutory law. It was found that most African countries have laws similar to Zambia, in that marrying more than one wife is permissible under custom, but not under statute. The Criminal Procedure Code. Video link conferencing. There are no provisions in the Act that would permit the court to authorize oral evidence to be adduced by way of video link conference. Such a provision would be necessary where appearance in person is impracticable due to factors including COVID-19 or other ailments and undue expenses. This is a novelty even to the South African legal system, where it is permissible if, inter alia, it is shown that the other party will not be prejudiced. Archaic provisions. Section 11 of the Act provides that the Chief Justice may direct that an offence that is triable by the High Court may be tried by the subordinate court. This provision was racially prejudiced as it was used where the offence was committed by an indigenous African. Preliminary inquiry. The introduction of the summary committal procedure under Part 8 of the Criminal Procedure Code is an alternative to the preliminary inquiry. The Commission found that the two modes were, at the time of enactment of the Criminal Procedure Code, necessary due to the centralization of the National Prosecution Authority and the need to mitigate delays in the committal of accused persons to the High Court for trial. However, the decentralization of the National Prosecutions Authority has resulted in the redundancy of the preliminary inquiry. The preliminary inquiry has also been criticized for being an unnecessary expense on the part of witnesses and for extending the time within which a matter may be concluded. Stakeholders submitted that the procedure is archaic and should be removed as it is rarely resorted to. Power of the DPP to offer no evidence. One of the ways in which criminal proceedings may be terminated is by the prosecution offering no evidence. This principle is provided for in Shamwana and 7 others versus the people. Stakeholders submitted that it should be provided for in order to ensure that the Criminal Procedure Code is comprehensive. Under the comparative study, it was found that similar to Zambia, many African jurisdictions rely on case law and archbold criminal pleading evidence and practice regarding procedure in offering no evidence. Hostile witness. The criminal law principle on how to proceed where a witness turns hostile is not provided for in legislation, but in case law in Munalula versus the people. Stakeholders submitted that it should be provided for in order to ensure that the Criminal Procedure Code is comprehensive. Under the comparative study, it was found that the Evidence Act of Australia provides for how a hostile witness may be dealt with. It states, inter alia, that a party who called a witness may, with the leave of the court, question the witness as though the party were cross-examining the witness. ZLDC and Technical Committee findings. Based on the findings, the following recommendations are made. In the Penal Code, all criminal offences, with the exception of regulatory offences, should be repealed from specialised acts and incorporated into the Penal Code. And all criminal procedures should be repealed from specialised acts and incorporated into the Criminal Procedure Code. This will prevent the duplication of offences, promote uniform application of the law, and ease administration of criminal law. Repeal or amend as appropriate provisions that are reminiscent of the colonial era. Provisions relating to defamation should be repealed, as they compromise freedom of expression and are inconsistent with international law and best practice. Redress can be sought through civil litigation. The words idiot and imbecile in the Penal Code and Criminal Procedure Code should be replaced with more appropriate term of a person with a mental disability in order to be consistent with international standards relating to persons with disabilities. Whilst it is desirable to repeal minimum mandatory sentences, in consideration of stakeholder views, there is a need to first develop sentencing guidelines that would ensure consistent and proportionate sentencing. The United Kingdom and South Africa have taken a similar approach by adopting sentencing guidelines. The Commission has compiled its research findings, including all stakeholder submissions and recommendations of the Technical Committee in the project report, and has reflected all recommendations of the Technical Committee in the draft Penal Code and Criminal Procedure Code bills, which are to be handed over to the Minister of Justice today at this ceremony. The Commission would like to thank the Ministry of Justice for entrusting it with the great responsibility of carrying out this law review process. Stakeholders in the criminal justice system who dedicated themselves to the consultative process, institutions in the countries visited for the comparative study, for being receptive to the Commission and being invested in the development of the Zambian legal framework, the United Nations Development Programme, and the German Agency for International Cooperation for facilitating the law review process through financial support. And finally, the Technical Committee chaired by Honorable Mr. Justice Chalum Chenga, who ably guided the law review process and shared their immeasurable knowledge and experience working in the criminal justice system. It is the Commission's hope and that of the Technical Committee that the work done will contribute to the development of a suitable and effective criminal justice system and the legislative framework in Zambia.